All right. Hello, everybody. Welcome to Clarity on SARA Policy 5.2, Essential Updates for Licensure, Compliance, and Enrollments. I'm so excited to join you here today. My name is Jonathan McNichols, and I'm the Manager of Policy and Stakeholder Engagement at the Midwestern Higher Education Compact, covering all of the small policy pieces that we all work with, including this. Just for everybody's information, we are recording this conversation, and the recording will be posted to our website after the presentation. We welcome all questions that you have and request that you use the Q&A box, and we will do our best to address all of the questions. Um, there are often times that there will be many questions for Chris, especially knowing how many we have here. And we're pleased to share that Chris has agreed to follow up in writing with any questions and his answers to the questions if we run out of time, and that we will post the Q&A to our website by end of day next Monday. Mary will post a link to this presentation in the chat for you to follow along if you needed. And upon closing out of today's meeting, you'll have an opportunity to take a brief survey, uh, and please complete it as it helps us plan and improve all of our future webinars. I am really excited to be joined by Chris Mall today. Chris Mall has over a decade of experience working in professional licensure regulatory compliance. He has supported institutions with students in all 50 states and US territories. He received his Juris Doctorate from Hamline University. His experience includes researching, analyzing, and interpreting professional licensure laws, regulation, rules, and policies, creating comprehensive student resources to navigate all stages of professional licensure, auditing graduate and undergraduate curriculum for compliance with professional licensure standards, and more. Through help, Chris partners with institutions to streamline processes, reduce risk, and build sustainable systems that support growth and student success. And we are excited to have Chris here to share insights drawn from his extensive experience helping higher education leaders solve some of the most pressing licensure and authorization challenges. And with that, I will pass it over to Chris to take us away.
Awesome. Thank you so much for that introduction, Jonathan. I could not have done it better myself. So I'm going to move right on to our agenda for our time together today. First, I'm going to go over the basics of SARA Policy 5.2. So what is that? We're going to look at the language together. Then we're going to dig into impacted programs and other offerings at your institutions. So just as a preview, it's not just your for-credit offerings. It could include non-credit as well. So we'll get into the fun details of that. And then I have some steps for compliance for your consideration. So this work can be overwhelming. It's a lot to take in, especially if this is new to you, or again, just expanding into that non-credit space. So we're going to walk through some concrete steps that you can work on together with folks at your institution. And then finally, how to get everybody else on board. So you might be a compliance staff person here today, responsible for this work, and trying to figure out how do you bring along the rest of the players at your college or university. So we'll talk a little bit about that as well. As Jonathan mentioned, I do welcome your questions. Please put them in the Q&A. We're going to do a brief pause for some questions in the middle, and then we'll have time at the end as well. If we don't get to everything today, I'll do my best to answer those questions in writing afterwards. And then finally, while I am an attorney, this is not legal advice that I'm offering you today. This work, like most compliance work, it is really critical to have the advice of your own counsel on this. So I will be encouraging everyone to make sure you're including your general counsel or other legal counsel for your institution when you're making decisions and determinations about this work. So without further ado, let's jump right into SARA Policy 5.2. SARA, by the way, State Authorization Reciprocity Agreement. I think most of you know what that is. That's probably why you're here. You're somehow related to that work. But in case you're not familiar with SARA, the State Authorization Reciprocity Agreement, it is a voluntary agreement that almost all states participate in. California is the exception, and it does essentially allow a college or university to be enrolling students located in other states or offering clinical or field experiences or internships in other states. That is a very brief shorthand for SARA. But let's dig into that policy 5.2. So there is a SARA policy manual that outlines a lot of responsibilities, limitations, things that institutions need to comply with in order to participate in the state authorization reciprocity agreement. And NC-SARA, the national entity, is the one that leads the policy process as far as overseeing that, and those policies can get changed from time to time. So we had a change last year. This went into effect July 1st of 2025 related to SARA Policy 5.2. And we'll look at the exact language here in just a moment. But essentially, the policy change is extending the licensure responsibilities to any non-Title IV program or offering at your institution. So before July 1st, 2025, the licensure requirements were just focused on your Title IV eligible programs. But with the SARA policy change, if you participate in SARA, you also now need to understand if your programs related to licensure are meeting the educational requirements in other states or territories, and make sure that you're following the disclosure responsibilities. So let's get into some of the details here. Taking a look at the exact language of SARA Policy 5.2. So this is that old version. This was in effect through June 30th of last year. I wanted to point this out though, because again, many of you have been involved in this work in the past. And so there were some significant deletions to SARA Policy 5.2 in addition to that new responsibility around non-Title IV programs. So let's take a look at the deletions. They're highlighted here in yellow, removing that reference to the specific section of federal code. And then we have deletion of that whole second paragraph, which talked about institutions using all reasonable efforts to make a determination about your program, if it meets the educational requirements in other states or not. And then you would have to provide contact information for any applicable licensing boards and really direct prospective students, to contact that board themselves in the event that you couldn't make a determination. So if you had states where, you weren't able to get an answer out of a board, or where you even hadn't dug into the research and requirements in another state, you would have had to be providing a link to that other state licensing board and directing prospective students there. That's all been removed. So again, just clarifying here what's changed in the last year with 5.2. So let's look at the current language for policy 5.2, which is in effect now. It went into effect July 1st. So the change with that first paragraph, again, highlighted in green here, it is applying the requirements around licensure to all non-Title IV programs. So in practice, this is an extension for most institutions. You weren't really paying attention to your non-credit offerings, your non-credit courses, and those that were connected to professional licensure typically were not being listed on public disclosure pages or otherwise included here. But with this change, if you're participating in SARA, you do need to be concerned with those non-credit offerings. So let's dig into the impacted programs, because I've been hearing a lot of questions and confusions from people really on, practically what does this mean? How is it going to impact what our college or university is doing? First, we have to start with licensure, what that means. So in this context, within SARA Policy 5.2, as well as the federal Title IV regulations, and just more broadly, licensure is really an umbrella term. So something could be called certification, certificate, authorization, registration. The list is pretty long. But the key is anything that's being offered or that is required by a state entity that is required for employment. So if you have a license, again, it could be called a certificate in some states or a registration for a certain occupation, but it's issued by a state government entity or territory government entity. And that thing, whatever it's called, is required to be employed in that occupation or profession in that state, then that's considered a licensure. And so by extension of that, a licensure program is anything that's been designed to lead to that state issued credential that's required for employment, or that a college or university is advertising or marketing to lead to that state issued credential required for employment. So let's dig into the design piece a little bit more here. Oftentimes, college or universities, it's pretty clear which of your programs or even which of your non-credit offerings have been designed for licensure. So if it's built around specific professional or curriculum standards, sometimes this could be a specialized or a programmatic accreditor that is directly related to a license. It's pretty easy to say that program has been designed for licensure and therefore is a licensure program. Examples of this would be things like a registered nurse preparation program or your elementary teacher program at the bachelor's level, or you could have a doctorate program in psychology, clinical psychology that's approved by the APA. Those types of things, pretty easy to identify if it's designed or not. It gets a little more squishy when we get into the next couple of bullet points here. So is there some sort of connection to a licensing or licensure exam? So if there is, if it's being marketed to prepare someone to sit for or to pass a specific licensure related exam, or if there's any sort of reporting where the college or university needs to report out information on passing rates for a licensure exam, those are pretty good clues that it is a licensure program. Another thing to keep in mind is what are the expectations of the graduates or of the faculty teaching the program or the program director. If the expectation is that most of the graduates will be seeking a license, then it most likely is a licensure program. So keep those criteria in mind as you're evaluating your own programs, both your Title IV programs as well as your non-Title IV programs. So the advertising piece, this one, again, sometimes it's very blatant. There's a statement on your website or in your catalog or in other marketing materials where it explicitly says this program is designed to prepare you to be a registered nurse, for example. Or it could be a little less clear than that, right? This program is designed to prepare you for a career in nursing. Well, exactly what does that mean, right? So it's really paying attention to the phrases and terminology that are used in your academic publications, your website, as well as other marketing materials to understand if it's being advertised as a licensure program. Similar to that are any references to exam eligibility or licensing exam preparation. You want to watch out for those. And if you're saying we're preparing you for this particular licensing exam, it likely is a licensure program. All right, I'm going to keep rolling here to the next slide and give you a few examples of licensure programs, and in particular, focusing on those non-Title IV and even non-credit offerings, because this is the new piece for all of us here with SARA Policy 5.2. So again, this does cover anything that is being offered under the institution's name, even non-credit offerings that are designed or advertised for licensure. So some examples of things that I've been seeing, non-credit offerings, these are going to be offered even through a workforce arm of the institution, sometimes even offered through a third party, not directly from the college or university itself. So things like phlebotomy or a pharmacy technician, medical assistant, real estate broker, things that are more of a short course or a couple of courses that are required for someone to get the relevant education and training necessary to qualify for a license. But these, again, are licensed professions in states. So it requires someone, in order to be a phlebotomist, they must hold that state issued license, or it's called a registration in some cases, in order to work as a phlebotomist. So going back to that key, right? Is it state issued, and is it something required for employment in the occupation? Kind of on the flip side of that, there are, of course, a lot of non-credit offerings or non-Title IV offerings that are really not licensure programs. And so these would not be covered or included under SARA Policy 5.2. And I've got a few examples here on the slide. So things like financial planner, there is a national private kind of certification issued if you're going to be a certified financial planner, but because it's not state issued, not required by the state for employment, it is not part of a licensure program. So, kind of along those lines, we've got construction technology as an example. So, often municipalities, so at that municipal level, might have some codes pertaining to who can do certain functions or the scope of what someone can do, but there's not a state issued license that's required for that individual person to be employed is in construction technology. So that would not be a licensure program. And then aviation mechanic, my final example, there are very specific requirements in order to work as an aviation mechanic. And in fact, there are FAA certifications that are required. But again, that's not a state issued. So it's not something that Iowa is going to be issuing a license to someone to be an aviation mechanic, or Wisconsin does not have a required registration issued by Wisconsin DPS to be an aviation mechanic. And so it's not a licensure program for these purposes. So a few examples here. I did want to point out that there often can be questions around continuing education type offerings in that non-credit space. So, if you have things that are designed for someone who's a licensed teacher, and they're going to come and take these courses really to expand their knowledge or learn a new skill or something like that. If it's not leading to a new type of license or an expanded subject area on their license, then it's not a licensure program. So if you think about it, a lot of professions or occupations that are licensed have continuing education requirements. And for the bulk of those, they will not need to be included as a licensure program under SARA Policy 5.2, because it's really about just truly continuing education for someone who's already licensed. And I think with that, I'm going to pause for some time for questions. If we've had any questions come in the Q&A, happy to field some of those now.
Yes, you have one. You got asked, what about non-credit CE courses that support the licensure already earned with professional development hours towards maintaining the license?
Yeah, so that's what I was just referencing there. If it really truly is for maintaining a license that someone already has or some other form of continuing education, it's not included as a licensure program. So again, I know that can be confusing because you're probably advertising it in some way as being relevant for a particular license type. But as long as that offering or course or program, whatever it is, isn't designed or advertised for a new type of license or an expanded scope of license, then it's not a licensure program. Anything else, Jonathan?
Yeah, there's a few more. One is, I think, one we hear kind of commonly, what really are considered licensure programs. For example, somebody mentioned that they hear construction technology is not considered a licensure program, but in construction management, most construction professionals are required to be licensed and bonded.
Yeah, so again, it's going to depend on the specific program, right? And what it's designed to do and what it's advertised to do, and also what's happening in your state as far as what's required for someone to hold in order to be employed in that profession or occupation. And so things like in construction, depending on what it is, if it's commercial type of construction versus residential, there could be a license that would be required. Again, depending on the state and exactly what the scope of responsibilities or what those activities are that the person is doing. So it's not, the examples I gave are meant to be illustrative, not completely definitive. It's possible that you might have something that's labeled as construction technology, but it's really related to some specific occupation within construction that might require a license.
Thank you. A few more. I think this one's very helpful. This gets to in-person versus like online courses. The ask was for you to talk about fully on-ground programs and the licensure requirements. For example, if a student has to be on the ground to enroll and will take all of their courses on the ground and the licensure program meets all requirements of the state, do they still need to include licensure disclosures for every state? And does that change at all if and when a student takes an online course within the program?
Yeah, so thanks. This is a little bit of a compound question, so I'll try to break it apart here. But first, this is good to talk about because I want to remind everyone the focus today is on SARA Policy 5.2. And of course, under SARA, if you are offering an on-campus program where students are going to be coming physically onto your campus to complete that program, then SARA really doesn't apply. The only time it could apply, of course, is if you're offering, supervised experiences outside of your state. So if there's clinical experience or some sort of internship or something that's happening outside of your state, then SARA would be relevant. There's of course exceptions to that, right? If you're doing field trips or other things as well outside of your state. But in general, if we're talking about a traditional on-campus program where students will be coming to complete it, then SARA doesn't apply at all. So this SARA Policy 5.2 would not be relevant. However, if we're talking about a Title IV program, of course, the federal Title IV regulations would still apply to that. So I'll answer it briefly, but don't want to get too in the weeds because I don't want to confuse people since the focus is on SARA today. But under federal Title IV regulations for your Title IV programs, if you have an on-campus program where students will be coming on campus to do the program, you could have your student location policy set up in such a way that it'll be treating those students as located in your state where your campus is. And if that's the case, then as long as that program meets the educational requirements for the state where your institution is located, and you disclose that on your public disclosure webpage, that could be the end of your responsibilities for that program. So again, it's going to depend on your specific student location policy, how you're treating those students at the time of initial enrollment. And then there is potentially a factor in there with being able to complete an online course during the first term of enrollment. But I'm going to pause there because now I'm getting into the weeds. So
Yeah, thank you. There are a few more about specific licensure programs, which I'll leave for written response at the end. But there is one that I think we should cover. It says on the PowerPoint, it says that this is effective as of July 1, 2025. Does that mean 2026 or 2027?
no, this was effective as of last July. So I was sharing, the prior version on the slide of what the language was, and then the current version of SARA policy that is in effect. It has been in effect since July 1st of 2025. I think I'll keep moving, Jonathan, and we'll have some time at the end for some more. Great. Okay, let's dig into some steps for compliance. And step one here might feel a little repetitive with what I was just talking about with, what programs are impacted, but it really is the first step in this process. So today, again, the focus is on SARA Policy 5.2 and its extension of responsibilities to your non-Title IV programs or offerings, including those non-credit licensure-related offerings. So remember, if it's designed or advertised for something that is issued by a state government entity or organization that is required for employment in that occupation or profession, that would be a licensure program, something that you would need to comply with these obligations under SARA Policy 5.2. It is not for things that are solely related to a private issued certification or credential or authorization or something. Even things that are just local and municipal based likely do not fit into this category, or things that are just issued by a federal government agency. Again, state issued is the language used in the federal Title IV regulation, and that is what SARA Policy 5.2 points to. It's just extending those federal Title IV obligations to your non-Title IV programs now. Okay, so I've said this a few times, but this could include non-credit as well, offered anywhere across your college or university, and even offered through third parties. So I know that I've been talking to many colleges and universities over the last 6 months about this, 6 months plus, and third parties are often involved. So they could be doing everything from designing the curriculum and actually enrolling students, all of the steps, or they could just be involved in a portion of those. But whatever the case, there's often a third party involved. So this could be something that, as a compliance staff person, you maybe don't have much insight into because, again, it's non credit. It's something that could be outside of the scope of your work up to this point. So it will be important to bring in the correct colleagues from within your institution, but also to have a connection to those third parties and the staff at those organizations and that are doing this work or trying to facilitate this work on behalf of colleges and universities. And then finally, just on identifying your non-Title IV licensure programs or offerings, this will likely require research to understand if a license exists. So similar to the question that I just got about, construction broadly, it is possible that there is some sort of offering that your institution has around construction that does require a license in the state where your institution is located. And so if that's the case, then it would be a licensure program for you. Okay, so once you've got your list of licensure programs nailed down, then the second step is to dig into that research and understand what the educational requirements are for licensure across the various states. I'm going to give my dog one more chance to stop barking, then I'm going to kick her out of my office. Sorry about this. All right, hang on one second. So sorry about the interruption. This is usually her nap time after lunch, but apparently something outside has caught her ear. So, so step two, you do need to dig in to the research to really know what those education requirements are for licensure in the various states that you are enrolling student from or you are recruiting or advertising for that particular licensure program. And in some cases, this will involve a detailed comparison of the course or curriculum in the program to a particular state's requirements before you can make that meets or does not meet determination. So how do you really go about starting this work? An order to consider is starting, of course, where your institution is located. Hopefully that one's easy and has already been done, and you know that the licensure program does meet your state's requirements for licensure. Next would be identifying where any of your current students are located. So let's say that you have a real estate broker workforce type offering for non-credit that is online. And so you're potentially enrolling students from anywhere around the country. You would need to find that list of where the current students are located, and that could be used to help kind of focus where the research and comparison is going to be done first in those states where you have students located. Also, good to consider any bordering jurisdictions. So of course, if you're an institution in Omaha, Nebraska area, you probably get a lot of students from Iowa that are crossing that border even physically sometimes to do things, but you're probably getting online enrollments as well. So it'd be important to look at those neighboring jurisdictions and anywhere that the licensure program is specifically being advertised or that recruiting is happening. Those are also important places to know if the program meets the educational requirements for licensure. And then finally, you may have a list of many other states where theoretically you could have a student enrolling from, you just don't have any currently. It's good to make those determinations on the front end in case you would get an interested student. That way you know if it meets or does not meet. This work, the research work and comparison work, unfortunately, it's not do it once and you're good forever. This is work that will be ongoing, and that's for a couple of reasons. States obviously can change their requirements for licensure really at any point in time. And I'll tell you, as higher education licensure pros, we are monitoring over close to 90 license types now. There are changes every single week across states. And so it is work that needs to be happening on an ongoing basis, this regular review. And of course, your curriculum or the offering or program itself could also change from time to time. So whenever that happens, you would need to do another comparison to states' requirements to make sure that it's still a meet situation or it does not meet. Just to note that there's not a particular cadence or time frame for review that is dictated by the US Department of Education or by SARA. So it is up to you for your college or university to come up with a cadence and a process that makes sense, that supports that regular review and potential changes that could be happening across states. Also important is documentation. So the research and the program comparison should produce something that can be retained where it's clear how a meets decision was made or it does not meet. So this could be in a spreadsheet format, where someone has captured those requirements across the different states and then put in information about your program and made a decision. It could be just a Word document. It needs to be something where it's clear that whoever was doing that comparison to the unique state requirements considered what those were and came to that conclusion that it meets or does not meet. If you're communicating with the state licensing boards as part of this research and potentially comparison, you of course would want to retain that documentation as well so that it could be presented in the event of an audit or questions from anyone. With communicating with state licensing boards, often they're going to point you back to the law or regulation itself or point you to a specific page on their website. It's very rare for a state licensing board to give you a concrete yes or no, your out-of-state program meets these requirements. That's very rare. That they simply don't have the legal authority to do that in most cases. Or if they maybe do have the legal authority, they don't have the staff capacity or the desire to be supporting out-of-state institutions in this way. So it's unfortunate, but that's the reality of the process today, that it's highly unlikely to be able to email another state's real estate broker licensing office and get a very concrete answer for your particular program. What you can do, though, is send them more general questions if you're having trouble researching, finding what the actual requirements are or understanding what they mean. Often they will give you some sort of answer or point you to some additional resources on their website or elsewhere. Okay, we're up to step 3 now, which are the disclosures themselves. And so for those of you, again, who've been doing this work, this will be familiar because as a reminder, the SARA Policy 5.2 requirements point back to the federal Title IV licensure requirements. So these public disclosures and individual direct disclosures are the same that exist for the Title IV programs that your institution is offering. But just as a reminder, or in case you're not familiar with this work, there is a responsibility to make public disclosures as well as individual direct disclosures for your licensure programs. So for your public disclosures, you need to indicate if a licensure program meets or does not meet the educational requirements for licensure, again, where your institution is located, as well as where any students enrolling in your program are located at the time of initial enrollment. And this is where that distance education definition, and if they're taking a course online, potentially during the first term of enrollment, comes into play. But again, our focus today is on SARA. So keep in mind, this is only going to apply to your non-credit offerings that are being offered via SARA, so across state lines, right? So this will not come into play for SARA for any of your on-campus kind of programs. Okay, so most of you have a public disclosure webpage where there is information for your Title IV programs currently listed, if it meets the educational requirements or does not meet in certain jurisdictions. It would be wise to update that webpage and put these non-Title IV offerings there as well. And so it could be a little bit clunky because, again, often there's a third party who's managing these types of non-credit or non-Title IV offerings. So you might need to think about how you're going to direct people's attention from that third-party web page to your public disclosure page, or vice versa, to get people looking at the right information in the right place, but just making sure that they're able to easily see and understand those disclosures about meets or does not meet. Another thing just to note here, again, I mentioned it before, but it's important, so I'll say it again. For claims about career outcomes, in particular, if a third party is managing this business for your institution, really review what's on that third party website. What are they saying that someone who completes that offering, that set of courses, what will they be able to do when they're done? And make sure if it is sounding like something related to license, that everyone's on the same page on whether or not that's a licensure program, which again might require that step 2 research before you're able to understand that. But oftentimes, third parties don't understand the nuances of this work and could have some marketing language that makes it sound like a licensure program when it's really not. So it would be a matter of cleaning up that language, making it more clear what the program is designed to do or not designed to do. Okay, let's turn to individual direct disclosures next. And these are only applicable if you have students located somewhere where the program does not meet the educational requirements for licensure or where it hasn't been determined yet. So if it's a meet situation, you do not need to send a direct disclosure for that. But if you have students located somewhere where the offering does not meet or you haven't determined yet, you should be sending an individual direct disclosure. So some things to keep in mind with this are the timing requirements. So for prospective students, this would be sent prior to initial enrollment in the program or offering. One challenge with this non-credit or non-Title IV work could be there might not actually be an enrollment process. So again, I've been working with many colleges and universities. I know that often it's as simple as someone signing up on your website and clicking, register, putting in their credit card information, and they're able to move forward. Or if it's through a third party, that third party could have a similar process that's very abbreviated, where it's simply just collecting that person's information, payment, and voila, they're in that course or that offering. So it's a little clunkier to think about how you're going to get these these individual direct disclosures out as close as possible to something around that initial start or initial enrollment time. For your current students, it's within 14 calendar days of a change. So this could be that your student notifies you they're changing location, so they're updating an address in your student information system, or otherwise notifying you of a change. You would have 14 calendar days if their new location is somewhere that does not meet the educational requirements or there hasn't been a determination made. So again, can be a bit of a challenge because I've heard from many institutions that these non-credit students are not even in the same student information system as your Title IV or your for-credit students are. So it's really thinking about the processes that are currently happening for these non-credit offerings and how you can make things work as best as possible given the constraints that might be in place because of that. So kind of continuing with that same theme that I was just mentioning for individual direct disclosures, there are some unique challenges here with step 4. So step 4 is about enrollment restrictions and written attestations. And this is really related to the program participation agreement certification regulation, section of regulation in Title IV. So you'll see my note there at the top. While licensure disclosures are important and that's specifically called out in the SARA policy language, there is a connection to PPA certification by reference in the federal Title IV regulation itself. So NC SARA council and staff have indicated that this step 4 would be necessary to have enrollment restrictions in place for students located somewhere where the program does not meet or you haven't determined. The exception, of course, is the written attestation. So again, same requirements, same process that exists for your Title IV programs. It's just extending that to your non-Title IV programs, and again, potentially non-credit offerings even, if they are licensure. So shorthand, students should be located somewhere where that offering meets the educational requirements. If they're not, they can still be enrolled as long as they're willing to complete a written attestation. And the written attestation, some things to consider with that, it should make clear to the part of the process should make clear to that student that that program or offering does not meet the educational requirements where they're currently located. If that student indicates something along the lines of, well, I actually intend to seek licensure and employment in this other state, and if the other state does, if your program does meet the educational requirements in the other state, then a written attestation could be a possibility. So in the written attestation, that student would need to affirm several things. They would need to affirm that they had this interaction with someone affiliated with the program. They understand that the program or offering does not meet the educational requirements where they're currently located, but they actually intend to seek licensure and be employed in a different state where your program does meet the education requirements. They do have to name a specific state. So it can't be a vague statement like, I'll figure it out, I'll get licensed somewhere else, or it can't list several options. It does have to be one specific named state or territory where the program meets the educational requirements. So again, if you're already doing this for your Title IV programs, it's basically extending what you're doing to your non-Title IV programs and offerings. Okay, some challenges, right? Along the same lines as those direct disclosures, we have timing consideration. So often it's not an actual enrollment or admissions process, but it could just be signing up for something on a web page. So how are you going to integrate enrollment restriction and a written attestation into that? I know some third parties have been working hard with colleges and universities to figure this out and create a viable process so that they can stop people located in certain places before they can continue with that registration process. And then documentation, again, could be a concern here, especially if your non-credit learners are in a different system, especially if you have a third party managing all of this for your institution. You might not even have direct access to that student's information yet at this point. So something to work towards. This is step 4 for a reason, because the other pieces are important to get started on right away and eventually working towards this step 4. So I'm going to talk briefly about some strategies, and then we're going to open it up to questions again. So as I mentioned, I've been meeting with many colleges and universities since even before July of 2025, and really trying to work with them to understand how are we going to accomplish this at our institution to bring in our non-Title IV and non-credit offerings into the licensure compliance processes that we have already. So one thing you might need to do is convince your internal partners why this is important, right? Why we should spend time on it, why to focus on it. So of course, the biggest one is the ability to participate in SARA. This is a SARA policy, same as any other SARA policy. And so institutions need to be doing their best to comply with all those SARA policies in order to continue participating in the state authorization reciprocity agreement. And of course, participating in SARA is a huge benefit to institutions. It allows you to enroll students who are located in other states or complete their supervised experiences in other states. If you weren't participating in SARA, the institution would need to seek out individual authorizations or permission to do those things in every other state. So of course, many of us who've done this work for a long time remember those days before SARA. Most of us don't want to go back to that. And it could be a scenario if an institution is not complying fully with SARA policies, that you could lose your ability to even participate in SARA. Another reason to do this, if your colleagues need some convincing, is this is simply good consumer protection, and it's good to help ensure that anyone coming to a course or a program or an offering, whatever it is, affiliated with our college or university is going to be able to get the outcomes that they're expecting. So knowing that that real estate broker course that's available online to anyone anywhere, that it meets the educational requirements wherever, is a really important thing. Otherwise, you could end up with people completing your courses or your offerings who can't do what they were signing up to do in the first place. That's not going to be a good outcome for your students. Obviously, not a great thing for your institution as well. And that kind of scenario, unfortunately, could lead to legal complaints, right? And I don't think any of our institutions want to try to defend a lawsuit with students claiming that we were misleading them about a particular licensure-related offering, or that we weren't clear about what that outcome was going to be for them after they invested the time and money. So engaging in this work is a good way to reduce those types of risks as well. I've already covered third-party providers quite a bit, but again, I can't stress it enough how important it is to be connected to these third-party providers. Many of your colleges and universities are basically outsourcing all of your non-credit related things to these third-party providers. And so they could be handling everything from start to finish for your non-credit students. But because it's offered under your institution's name, it is part of your SARA authorization, because it does cover those courses as well, that non-credit work. So important to know how they're handling these things. Make sure that you have a contact there. If you're a compliance person, that you have a contact, if possible, directly to the third-party provider or whoever at your institution is responsible for that relationship, that they clearly understand what SARA Policy 5.2 requires and how that third-party provider is helping support your obligation as an institution. So ultimately, it is up to you as an institution to make sure that SARA policies are being followed. And then finally, wanted to address the potential overwhelm. So I mentioned this before too, but I know this can be a lot. So just getting our arms around the Title IV requirements and being able to have, a solid public disclosure page and an individual direct disclosure process, and have that written attestation exception as a possibility, and making sure that our academic partners were able to weigh in on those curriculum comparisons and make the determinations. That is all a lot to do just for our Title IV programs. So now extending that to your non-Title IV as well can seem like too much, right? It's a tsunami at times, but you just need to start somewhere. So reflect back to the steps. Step one, just get your licensure program list nailed down. If you can do that in the next month or so, that's a great start. Get that nailed down, and then work to get a team assembled that's going to help support this. So definitely needs to include any internal partners like your workforce program, other parts of your institution that could be offering non-credit things, and then for sure, any third-party providers. So try not to be too overwhelmed, but get started somewhere and continue down the path for compliance. So I finally wanted just to point this out. I think everybody understands this, but with your SARA authorization, really it's important to know what your state portal entity expects, right? So it's not NC SARA that's technically giving you your authorization. That is done through your own state portal entity. So maybe worthwhile to have a conversation with a staff person at your SPE to, what are their thoughts on SARA Policy 5.2? What are they seeing other institutions in your state doing? Or what are their expectations going to be when it's time for you to renew on SARA Policy 5.2? And then I mentioned it before, but definitely include your counsel in discussions around this and decisions that are being made on, how are we going to potentially set up enrollment restrictions for these non-credit offerings, or how are we going to be working with the third parties? Who's going to do what in these processes, it's really important to have your counsel on board with those discussions. So. All right, I'm ready for some more questions, Jonathan. I'll just page through my resources slides here. Again, you'll all have access to these slides. I know those were being put in the chat, I believe, along the way as well. But there's some great resources, including some from HELP. You can sign up for our email list and have access to latest updates as we get them on licensure compliance and changes. We also offer a tool that can help with the research piece. So it's called the bookmark, and we've thoroughly researched and compiled information for over 80 different license types. So if you're interested in any of that, feel free to reach out to help. We'd be happy to connect you. We also have some great resources from NC SARA and the State Authorization Network specific to licensure. So encourage you all to check these out as well. It can really help you get started in this process or continue with your compliance efforts.
All right, Chris. Well, we currently have 20. Ooh, am I frozen? We currently have 23 questions up. I'm going to start by filtering the ones that relate to non-credit and distance. That's where that's kind of a focus on SARA right now. Starting is, are there institutions working with HELP who have displayed the information on their website well and in line with newer ADA guidelines? And if so, are you able to share who those are?
Yeah, so I think actually this is one I'll respond to in writing afterwards, Jonathan, because I can pull out a couple of examples and provide the links. I'll wait on that one, but that's a great question.
Perfect. Oh, sorry, I just got jumped around. Related to third parties, one person said that quite a bit of institutions are contracted with Ed2Go, and if they are advertising on the third-party website but not on the institutional website, would they still need to be considered as a licensure program?
Yes. So if there's a connection from your institution to the third party, and let's say it's Ed2Go, even if Ed2Go is managing the entire process, including a web page advertising, whatever that course is, if it's being offered through your institution, so if you're getting revenue back from Ed2Go for those enrollments coming in, then it would be part of your authorization under SARA, and so you would need to comply. If you're simply, I'm not as familiar with all the options for relationships with these third parties, in particular, Ed2Go, how they might structure it, but if it's not being offered under your institution in any way, and if you're just maybe directing people to Ed2Go, if they have an interest in something that you don't offer, and there's no revenue coming back to your institution or anything like that, then it likely would not need to be included. But I think the former is how most people have it structured. So even though they're partnering with a third party like Ed2Go, there's still a connection to the institution, whether it's branded directly as the institutions or if there's some sort of revenue, share happening and coming back to the institution.
Thank you. Next one on the docket is, if a program leads to a national certification and national certification is part of a state certification requirement, would we need to comply with all state requirements as well as the national requirements?
The short answer, I think, is yes to that. So if there's a state issued certification that's required for employment in that occupation, you would need to satisfy those requirements in additional to whatever the national certification requirements are. And there often is a connection between some sort of national certification or credential and a state issued license. Sometimes the education requirements are very similar or even the same. A state might adopt a standard that says, well, any applicant for a license that brings us that national certification has met the educational requirements. But it's still important to know what the requirements are in every state that you are going to be enrolling students or again, are recruiting or advertising. Sometimes they throw in their own kind of unique thing as an educational requirement, even if it's mostly aligned with the national standard.
Thank you. The next one I have here is related to third party, but I think it expands outwards a little bit. Oh, it disappeared on me. Okay. So this one's a little tricky, but I think it expands out of third party a little bit. But the question was, we have a third party that provides our real estate broker licensure program, but it is offered through our non-credit department. Their program is designed so that a student can take varying course requirements in order to meet a particular state licensures requirement. Are we okay to say that we meet in all states with the flexibility of that program?
Yeah, so I would say that kind of scenario, generally, yes, you're going to be able to say you meet in every state or US territory, as long as it's been confirmed that students are actually able to tailor it specifically to every state's requirements for real estate broker. So it sounds like the third party has that knowledge and research completed, and they know what specific courses or hours that somebody needs in each of the different content areas. So as long as they're tracking students into, I want a Nebraska license, and so they're getting the right curriculum, or I want an Illinois license and they're getting different curriculum, I think it would be safe to say that it meets for those in that case.
All right, I have one more question, and then we will answer all the remaining ones later. But this is, I think, covers a few of the weirder areas. And the question is, what if you have a licensure program that does not meet the licensure requirements in your home state, but you do not enroll in your home state, including if it's a non-Title IV program?
Mm-hmm. Yeah, so this one I'm gonna just answer it from the non-Title IV perspective. So again, I think there is a difference here if we're talking about Title IV or not. But so remember, for SARA Policy 5.2, it only applies to things that are being offered under your SARA authorization. And so if someone's enrolling students from their own state, that doesn't apply. SARA is not applicable for the place where your institution is located. So I think there seems to be a reasonable argument that if you're not enrolling students from the state where you're located because you don't meet the educational requirements there, and you're very clear about that, but there's value to students in other states because the program does meet it there, that for your non-Title IV, that would be something feasible because your SARA authorization is covering those activities outside of your state anyway. And so as long as you're ensuring that you meet the educational requirements where you're enrolling students from out of state, or otherwise, having them complete a written attestation, then it seems to me like that would be satisfactory for SARA Policy 5.2. Again, this is only for non-Title IV things. But I would encourage you to connect with your SPE, your state portal entity staff, and pose this question to them, or otherwise try to confirm with NC SARA kind of what their thoughts are on that. But that's my thoughts for whatever it's worth.
Well, thank you so much, Chris. And thanks everybody for joining us today to learn more about this topic. We really appreciate you, Chris, with sharing your expertise to us all. As said before, we will be continuing to answer all of the questions in a written format after the webinar. Just give us a couple days to get that up, and those will be posted on our website. And please complete our survey that Mary will attach in the chat. The survey is really helpful for helping us learn how to improve and expand these webinars to make sure we're providing the most helpful tools for you all. We've already posted the presentation to our website, and we'll continue to post the recording of the event today soon. And we hope to keep you informed with MEC by subscribing on our website. Feel free to subscribe there to continue to gain more information of the work we're doing and all the great tools we can provide. Thanks again for joining us all, and I hope you all learned a lot.